The next matter before the court is Hoover versus City of Elyria. Each side will have 15 minutes. The appellant may reserve up to 5 minutes for rebuttal, and if you'll let me know how much time you wish to keep, I'll make a note of it, and I'll give you a hand signal when you get to that point. Thank you.
Your Honor.
You may proceed.
Good morning, Your Honors. My name is Mike Harvey, representing the appellant, Mr. Hoover. I'd like to reserve 1 minute for rebuttal. Folks, this matter is on remand, as the court is well aware. We're here on the previous decision of this court to remand back to the common police court. Judge Arredondo heard the hearing, heard the matter, made a finding on or about March 17, 2016, which Mr. Hoover does not agree with. This court was concerned with a couple of different points, and before I launch into that, I'm not gonna reiterate the entire record. I'm gonna make a few.
You're going to reserve any time?
I asked for 1 minute.
1 minute.
So I'm sorry. Yeah, I apologize. I probably didn't say it loud enough.
Oh, and we usually ask you to come up to.
Oh, yeah, sure.
It's easier for us to hear. I'm sorry.
That's fine.
Yeah.
This is the first time I've been this close to the panel.
We won't throw any.
All right, thanks.
You're on YouTube.
Okay. All right, so, Your Honors, because this is on remand, because this court has already heard this case on the record extensively, and because obviously the court has the well-developed briefs of not only myself, but my esteemed opposing counsel, I'm going to make this short. Judge Arredondo's decision of March 17, 2016, we believe, Mr. Hoover believes, is an error. The court was asked to consider, Judge Arredondo was asked to consider whether Elyria Civil Service Commission's application and interpretation of the code section 165.29 was applicable to the situation at hand. And the court found that it was, and I would simply make this point again, that code section, which I apologize to the court, I know I've talked about this extensively. That's not a code section, actually. It's an administrative code section, a city code section. Refers specifically to applicable federal and state rules, laws, rules, regulations, and guidelines. I've said this before, I'll say it again, that by allowing the Elyria Civil Service Commission to determine on its own, non-lawyers, along with Mr. Brubaker, who wasn't a lawyer, and everybody, and of course, and I made reference to this in the briefing, and I want to apologize to the city lawyers at this point. The city administration that's here now in place wasn't the folks that were in place when this all occurred. I want to make that clear on the record. But the folks that were charging this through, first of all, they knew, and I believe the Ohio Ethics Commission certainly found this to be the case, that they knew that there was an ethical problem in the water department, which Mr. Hoover had complained about to the Elyria Safety Service Director, who since passed away. Mr. Hoover was complaining to anybody who would listen about the conflict of interest and the nepotism in that department. And so it stands to reason that you take a simple statement, as disgusting as anybody might find it to be, which I don't personally find it to be discriminatory, I find it to be disgusting, but it was a stupid thing to say. But it wasn't discriminatory under this code section or under any semblance of federal or state law, as I understand it. And so for a Civil Service Commission to just decide willy-nilly on their own, whatever they thought was discriminatory, without any context or following of the law of a state of Ohio or federal law, is a recipe, in my estimation, for disaster. But the court found that to be the applicable code section and went that direction. Also, the court found that the decision by the Civil Service Commission was supported by the preponderance of substantial, reliable, probative evidence, which we also disagree with, because, again, the Civil Service Commission said that they didn't find that the complaints Mr. Hoover made to the state of Ohio about nepotism and conflict of interest to be of any real import to their decision-making. And yet, when we look back on the factual record of this case, the man who was the so-called target of this joke, he ended up getting a job in the city. He works for the city now. He didn't complain about anything. The only person who made the complaint was his boss, the subject of the conflict and ethics charges. It was a complete and utter setup. We went through Civil Service Commission, which was, look, I understand. I chair the Civil Service Commission where I grew up. I know how it works. The problem is, it's not a court of law. It's a court of whatever the city says it is, and you try to get to the court. Judge Burge saw through that. I think I found it ironic that he was on the docket for today. But Judge Burge saw through that, and I know the court overruled that, I got that, but the point is he saw through that and said, listen, this is not discrimination under either the code section or federal state law, and so we're just gonna get rid of that penalty. And ultimately, Your Honors, I'd like to have this matter reversed and define Judge Arendano's decision to be unsupported by the actual full record. And of course, I'll take any questions the court may have, because otherwise, what I've said is in the briefing anyway. Thank you, Your Honors.
Good morning, Your Honors, and may it please the court. My name is Amanda Deary. I'm Assistant Law Director. I'm here on behalf of the City of Elyria. I would note that on or about April 28th of 2014, this honorable court issued a remand order to the Lorain County Common Police Court, and in that order, there were specific instructions to the trial court, and I would quote it, that the trial court was directed to consider the entirety of Elyria's anti-discrimination code and determine whether the Civil Service Commission's decision is supported by a preponderance of substantial, reliable, and probative evidence in the record. I would note that that standard of substantial, reliable, and probative evidence is in keeping with the Ohio Revised Code provision of 2506.01. I do understand, after having read the brief of Mr. Hoover, that he does take issue with the previous order of this honorable court. He also, as a result, takes issue with the trial court's decision on remand that was issued on March 17th of this year. However, I would note, Mr. Hoover did file a notice of appeal and also a memorandum of jurisdiction from this court's April 28th, 2014 remand order, and the Ohio Supreme Court declined jurisdiction in that matter. He also, at the same time, filed a motion for reconsideration with this Court of Appeals, and that was denied on August 8th of 2014. And in keeping with the law of the case doctrine, as has been discussed by this very court in Zimsack versus Tanner in 2013, he should not be permitted to relitigate previously settled issues as far as what has been set forth. In Zimsack, this court stated, the law of the case doctrine provides that the decision of a reviewing court in a case remains the law of that case on the legal questions involved for all subsequent proceedings at both trial and reviewing levels. I would state that Hoover did not initially make procedural arguments in this case. This record is quite dense, if you will. I would note that now Mr. Hoover makes arguments citing alleged flaws in the Commission's procedure. He cites that they're not lawyers, that they are lay people. I would note that there is a very, very lengthy transcript from the administrative proceedings. The Commission is an administrative tribunal. It is sanctioned not only by the charter of the City of Elyria, but by the Ohio Revised Code, and that there were no procedural arguments made. There was no cross-appeal taken in this initial appeal, and that the only thing in the record that reflects that Mr. Hoover had issues with the Commission, other than that he didn't like their decision, but was in their counter statement of the facts. I would say that the record reflects that on remand, Judge Arendano, the trial court level, took this honorable court's marching orders very seriously. The trial court ordered that each side file position statements on the remanded issues, and furthermore, the trial court scheduled and heard oral arguments pertaining to this court's remand order. In its March 17, 2016 decision, the trial court stated that it reviewed the record from the Civil Service Commission, including the transcript from the administrative hearing before the Elyria Civil Service Commission, and the court included specific cites to that transcript in its entry. And the trial court ruled that after considering the entirety of the city's anti-discrimination code, I would note that 165.29, contrary to my esteemed opposing counsel's representation, 165.29 is a codified ordinance of the city of Elyria. It's not just administrative, and I shouldn't say that because administrative code is very much law, but it is a codified ordinance. But after considering the entirety of the city's anti-discrimination code, that there existed a preponderance of substantial, reliable, and probative evidence in the record to support the Elyria Civil Service Commission's decision. I believe that that is what the trial court was instructed to do by this honorable court in its earlier, in the remand order, and that is what is on review here, and I would ask that this honorable court focus its review on that. I believe that many of the arguments and assignments of error that my opposing counsel has set forth on behalf of Mr. Hoover have been attempted to be litigated and relitigated ad nauseum, and I don't believe that that is appropriate. And I would respectfully request that this honorable court would affirm in total the March 17, 2016 decision of the trial court. Thank you.
Your Honors, the city,
And you said you only wanted 1 minute.
I did, thank you, Your Honor. The city still hasn't addressed the finding of the Ohio Ethics Commission, finding that that Mr. Hoover's own boss reached a settlement with that commission where he was found responsible for certain items, specifically benefiting his own son, which was Mr. Hoover's competition, if you will, in trying to continue with his job at the water department. The council's point about the remand order is correct, and I acknowledge that as a situation. However, the breadth of this court's remand back to Judge Arredondo, I think, vitiates the issue of that legal argument under the circumstances because of the breadth of what Judge Arredondo had to decide. And finally, Your Honors, I would just ask that the 9th District, please give this man an opportunity to get his classified civil service position back. Thank you.
Thank you. We'll take the case under advisement and send a copy of our